Hello, and welcome everyone to our channel webinar. Today, we will have Tilleke and Gibbins law firm with us today. My name is Nantala Salijan, Head of Market for ANZ Laos, and also Austrian Lao advisor, and I will be your moderator today. Today, we will very delighted to have Tilleke and Gibbins law firm, a leading law firm in Southeast Asia with us, who will take us through and give us insights on the e-commerce law in Cambodia, Laos, and Myanmar. So let's not waste any more time. Let me hand over to Cambodia. Let me introduce you to Jay Cohen, partner and director, and Jandavia, and associate from Cambodia to give us insights, please.
Great. Well, thank you very much for that. Thank you very much for that introduction. So as mentioned, today we're going to be talking about the e-commerce framework in Cambodia. So we're going to talk about some of the regulatory obligations. We're going to talk about the regulatory framework, some of the obligations, and then at the end, we'll talk about the bad stuff like sanctions. So for today, we'll start off with talking about the regulatory framework. Then we're going to talk about some of the licensing requirements. And then we're going to talk about some tax obligations. There's been some really new changes recently that I think will be of interest to a lot of our overseas viewers. And then I'm going to hand over the presentation to my colleague Chandavia, and she's going to talk about some of the consumer protection obligations under the law. She's going to talk specifically about online contracts. I think that's an issue that a lot of people have concerns about. Can we sign contracts through electronic means? And then lastly, the topic of sanctions. So for the regulatory framework, what I've done here is just simply listed out various laws that relate to like the regulatory framework for e-commerce. Now, the points that I want to highlight, the main law is the law on e-commerce, and that came out in 2020. So if you're doing any sort of research on e-commerce laws, that's really the place to start. And that talks about, that sets the framework for e-commerce. It clarifies that, yes, you can sign contracts, that electronic communications are valid forms of communications. It clarifies the scope, like who does it apply to? Does it apply to intermediaries and e-commerce service providers? It gives some insights into whether it applies to like offshore companies. Then it has a number of other e-commerce related obligations. So that's really the starting point. Now, many people, when the new law on e-commerce came out, a lot of people asked, can I go ahead and apply for licenses? And the answer was not yet, because you needed implementing regulations. So what you see below are various like implementing regulations. Now there's one from 2017. So that was actually a small regulation that existed before the e-commerce law. And then you see some sub-decrees from 2020. So basically those sub-decrees really started to set the framework by which people could start to at least apply for e-commerce licenses. It set, what kinds of things would be required. It gave some more details about who would have to apply. But then really, the only time you could really apply for one of these licenses became in 2021 when they made the application available. So you had the regulations, but you didn't have the application until 2021. Now, the next part I want to highlight in terms of laws and regulations are the tax-related regulations. And this is where we've actually seen some really interesting movement, where starting in 2021, the government made some amendments to the regulatory framework and added a new law, a new regulation, that really potentially has changed some of the tax compliance obligations for offshore companies. So I'll just sort of we'll talk about it in more detail a little bit later. But the first one, the practice on income tax, addressed issues of permanent establishment. Who's considered like a permanent establishment in Cambodia, who has to pay tax in Cambodia. And then they came up with a new regulation that specifically targeted offshore companies. So we'll talk about both of those in a little bit. But all these laws on these two slides, if you're doing any sort of your own homework, these are the laws that regulate e-commerce currently in Cambodia. So one of the main questions is, what is the scope of the e-commerce law? And a lot of offshore companies want to know, because of course with e-commerce, how does e-commerce take place? You've got companies in Australia, in the United States, in the UK, in Thailand, and they're doing business in Cambodia through websites, offering goods, offering services. So of course, people want to know, are they covered by the e-commerce law? So when we look at the e-commerce law, up at the very beginning with Article 1, it talks about the purpose of the law. It talks about how it's managing e-commerce in Cambodia and with other countries. And that's what's really important. When people talk about the scope of the e-commerce law, they're often looking at this Article 1. And based on that, a lot of people come to the conclusion that this law potentially can regulate offshore e-commerce service providers, because these e-commerce service providers are doing e-commerce between Cambodia and wherever their home country is. So this is really the clause that sets the scope of the e-commerce law. Now, when we look at what are the regulated activities, again, we're talking about e-commerce businesses here, so that's what we're going to focus on. So under the e-commerce law, it really targets two different kinds of businesses. So the first is what we'd call intermediaries. And the description for an intermediary is really high level: sending, receiving, transmitting, and storing e-communication. So that's a super broad business scope. But when we look more specifically, there's some other regulations that give some more concrete examples of what kind of businesses that could be. So that could be telecom service providers, these network service providers, internet service providers, online payment services, and again, intermediaries that are passing information through their networks between businesses and consumers. The other one, and that's the other business that's regulated, and that's the one we're going to spend more time talking on, are the e-commerce service providers. Now, to be considered an e-commerce service provider, it's a very broad scope again, and it just means you supply goods or services through e-commerce into Cambodia, and it includes all kinds of goods and services except insurance. So there's one exception. So again, for what kind of businesses would be an e-commerce service provider? That's what you traditionally think of as websites, all these e-commerce platforms, online marketplaces. So it's a really broad scope of businesses that get captured by these e-commerce service provider regulations.
What's the mark?
So after sort of realizing who's covered, the next question is, okay, so if you're an e-commerce service provider, you're doing business through e-commerce with Cambodia, the question would be what would be the licensing requirements for our e-commerce service providers? And it's really interesting. It's really quite easy. We've broken it down to basically two categories of people. One would be companies and branches. So they've got one sort of regulatory regime. And then you have something different for natural persons and sole proprietorships. So the first one, we're going to start with companies and branches. And it's really a two-step process to get licensed if you're an e-commerce, if you want to do e-commerce in Cambodia. So step one, you have to apply to the MPTC and get something called an online service provider certificate. So if you look back at the regulations, there was a regulation from 2017. And that's what this online service provider certificate stems from. This was a process issued by the Ministry of Posts and Telecommunications. They were very early in this space regulating e-commerce. So that would be step one. You have to apply for an online service provider certificate. And then second, you're then applying at the Ministry of Commerce for an e-commerce service provider license. So it's a two-step process. One thing to highlight is for the e-commerce license, it only became possible to apply for that in May 2021 when they actually had an application. So I'll just say for the last year or so, a lot of companies have been asking us. They knew the new e-commerce law came out. They knew you had all these sub-decrees coming out. They asked, can we apply today? And the answer was no, there's no application form. But now there is an application form, and it is available on the MOC website. So now it actually would be possible to apply for the e-commerce license. I will say the e-commerce license is valid for 3 years, and it is renewable. So I think that's something to also keep in mind. Now, if you're a natural person or a sole proprietorship, which might apply to a lot of small businesses here in Cambodia, then there's a different process, and you don't have to go to the MPTC. So you don't need that online service provider certificate. You can go right to the to the Ministry of Commerce and you're applying for something called an e-commerce authorization. So it's a little bit similar to the, same, but different than the license, but they're called authorizations as opposed to licenses. And for the e-commerce authorization, it's valid for 2 years and it's renewable. Also, the e-commerce authorization, if you're thinking about who does it apply to for natural persons and sole proprietorships, it's really a lot of small businesses. Also, if you think about sellers on Facebook, it could apply to sellers on Facebook. So again, a lot of like small businesses, I think, could be captured by the e-commerce authorization. Now there are some exemptions that only apply to natural persons and sole proprietorships. So I've listed them up on the next slide. I won't read it off. You can take a look at that and you can see, do you think you fall under some of those exemptions? The one that I want to highlight though, and this is sort of an important number, is it says that if your sale in goods and services have a turnover of less than $62,500 per year, then you're exempt from these sorts of requirements, from getting an authorization. Now, for the number 62,500 per year, I just want to highlight, in the law it says if you're below the threshold for being a small taxpayer, then you're exempt. So under Cambodian's tax laws, 62,500 is a very key number because currently that's the number for determining whether you qualify as a small taxpayer. If you're below that, you don't even qualify as a small taxpayer. And then you've got different licensing requirements as compared to the small, medium, and large taxpayers. So to be a small taxpayer, it means you're already kind of big. You already have turnover of 62,500. But if you're less than that, then you're exempt from getting an authorization. However, it's not completely, you still have some requirements. So even if you are exempt from getting an authorization, you still need to notify the Ministry of Commerce and provide certain information about your business. So you don't need to get an authorization, but there's still a notification requirement. And you have to provide information on the type of business operations, the name of your business, the electronic means used, payment methods, how are you collecting payment on the through the internet. So you do have to provide them like certain information, a notification, but you're not getting an authorization. The next part we're going to talk about quickly is tax obligation. And this is an area that's really been evolving, that I think potentially could have a big impact on offshore businesses. So the first new regulation I want to talk about is something called Subdecree number 65. And the purpose of Subdecree 65 is to impose some sort of tax on offshore service providers. So what's interesting about Subdecree 65, it specifically targets offshore service providers. And it says, and it applies to anybody supplying goods or services into Cambodia through e-commerce, and has this actual or estimated turnover of 62,500 per year. So if you're selling into Cambodia goods or services and your turnover is less than 62,500 per year, you're exempt from this requirement. However, if it's $62,500 or more, then you are falling under the scope of this new Subdecree 65. Now, as to what does Subdecree 65 tax, it requires offshore companies to collect and pay VAT. And we're going to talk about how that works. So on the bright side, it's not an income tax, it's not a profit tax, but it does require you to collect and pay VAT. So as for the mechanism of collecting an VAT, assuming you fall under the regulation, if you had turnover more than 62,500 per year, you'd have to register with the General Department of Taxation. Now, there's no application form yet, there's no implementing regulation, so you can't do it today, but we can anticipate that there will be regulations in the future. So as to how it works, it divides transactions into two kinds of transactions. So if you're an offshore company and you are selling to a non-VAT registered person in Cambodia, so typically a consumer would not be VAT registered, then the offshore company has to collect VAT and pay it to the General Department of Taxation by the 20th day of the following month. So for example, if you're a company in Australia and you are selling into Cambodia, you would have to charge 10% VAT. You collect the payment in June, you would have to make the payment to the General Department of Taxation by the 20th of July. So that's one way to do it. The other way has to do with offshore companies dealing with VAT registered persons in Cambodia. So typically that's businesses. If you're a business in Cambodia, you'd be VAT registered. So in that case, something called a reverse charge applies, meaning that the offshore company selling into Cambodia, although typically they have to impose and collect VAT, in this case, because their customer is based in Cambodia and their customer is VAT registered, the customer actually has to collect that VAT and then pay it to the General Department of Taxation on behalf of the offshore company. So that's how that obligation works. So again, for the Subdecree 65, it relates to the collection of VAT, and it divides it in again into the two kinds of transactions, business to consumer and business to business. Now, the last tax regulation I want to highlight has to do with the practice on income tax. And I think this one is actually probably the biggest concern to offshore companies, because this practice, it changed the definition of permanent establishment. So it clarified that permanent establishment means that non-residents who conduct e-commerce and derive profits from supplying goods and services into Cambodia could be a permanent establishment. Now, the significance of being a permanent establishment is if you have a permanent establishment in Cambodia, you're supposed to register an entity in Cambodia and then pay tax on income. So that's why I think this regulation makes people quite nervous, because it seems to suggest if you're an offshore company and you do business in Cambodia, you would need to, again, register an entity in Cambodia and pay tax. Now, there hasn't been further implementing regulations, and we're not aware of the government actually trying to tax offshore companies, but it's sitting there, and I think it's just something to think about and something to really watch. In the meantime, if you're an offshore company, clearly you have Subdecree 65, which says that now if you meet certain thresholds, you have to collect and pay VAT, but also again for Subdecree 65, there's no clear application yet for you to actually file. So these are the two big tax things to watch: Subdecree 65 relating to VAT, the change, the modification of the definition of permanent establishment, which could cause you to register an entity in Cambodia. So that brings me to the end of my portion. I'm going to hand it off to Chandavia to finish up our presentation.
So we'll start from part 4, which is, of course, the consumer protections obligations. So as Jay has already been discussed, it's like there are some people that are, some businesses that are under the scope of e-commerce law, and then there are certain licensing or authorization requirements under the law. And now we would like to take a look into the obligations that those companies or those businesses have over the consumer and the e-commerce transactions. So the first obligations is, of course, the obligations concerning the minimum information. So for this application, it's like the person that privately store information have to the information has to provide the consumer. I'm sorry. So in order to operate the e-commerce business, you have to provide a clear, correct, and understandable information to the consumer, so that the consumer is able to make decisions on the business transactions, as well as able to store those informations. And the requirement under e-commerce law provided that it could be a requirement like you have to share your name, your address, the form of contact, like your phone number or email, and then of course the pricings of the good or services, the term and condition on payment, whether it's cash on delivery or it's bank transfer. It could be the discussion on cancellation of purchase order, delivery, refreshment, etc. So those information are listed under the e-commerce law, and we could also see quite similar requirement under the consumer protection law as well. Under that law, it requires that the person, the seller, have to provide certain information into the consumer in order to make the decisions. And the requirements have been provided under the regulations. However, those regulations is not yet available. So as long as the information is correctly and understandable, so that they could make the consumer could make a decisions, it should be fine and compliant with the law. And next is the application concerning business communications. So some businesses might wonder whether they can send an unrequested email, like the email that they send to consumer without having the consumer requested for those email, just to make it or to notify them of the promotional sale, whether it's okay or not. And then of course the answer and the e-commerce law is yes, it's okay to do it, but you need to provide clear and easy options for the consumer to reject or opt out of such unrequested business communications. So when we talk about business communications, it's of course, it's not only like the communication through email. It could be a communication through messages or other medias. So as long as it's not requested, right? So it could be unsolicited email or in a form of spam email or spam message. And this applies not only to the sending of communication from Cambodia entity to consumer in Cambodia, but it's also applied to the sending of communication from abroad, like outside of Cambodia, to consumer in Cambodia, as well as the sending from business in Cambodia to consumer outside. So mostly, like you might have received the email that said, okay, here is what we are selling. This is promotional sale. You should click it, and then at the end of the email, you might see sentence that said, click here if you don't want to receive this type of email or this type of sale, or click here to unsubscribe. Like, so those information is like it's in compliance with the law as long as the consumer has the option to opt out, because it's really annoying to have the email or the communication being sent to you without having asking for it. And next is the application under for data protections. So here is like any person that privately store information have to have a mechanism to safely protect those information at all reasonable circumstances from loss, access, use, modifications, leakage, disclosure without authorizations. So then you might wonder like, okay, what are the mechanisms that I have to do, that I have to comply with? Well, the e-commerce law didn't provide a special guideline on what mechanism should be used in order to safely protect it. So it is safe to say like, as long as those mechanism is reasonable to protect the information, you should be fine. Okay, so it could be like a access control mechanism or data integrity, so that it could protect the data from being lost or from damage to those information. So with this mechanism, you should be compliant with the law. And you might also wonder like, what type of information qualify as data? Well, if you look into the law on e-commerce, data was defined in a broader way. It's like anything including numbers and text to symbol, as long as it's suitable for use in database or electronic systems. So it could be anything. And therefore, we would like to recommend the businesses to take a conservative view in taking care of the data information they are storing, because according to this definition, it not only includes like ID number or name of your consumer, but it could be like anything, including the message that they are sending. So you should be careful with this data protection provisions. So the fifth part is talking about the online contract. So online contract here is referring to, online contract here is referring to the contracts that being made electronically. Okay, so the e-commerce law have a really simple concept of when electronic contract is considered as valid. It's only provided that as long as the offer and acceptance are consistent, the contract that is made electronically is considered as valid. However, the law didn't provide a clear rule as to when, how, or what form the contract could be made. Like, does the contract would be formed when the consumer click agree to the term and conditions, or it would be formed when you click yes or reply to the email by saying yes? There's no clear rule on that. It's only provided that the offer, acceptance, and contract could be electronically made. And if you look into the law, it said like any requirement that, any provision that requires things to be in written form could be fulfilled if it was made in electronic form. Furthermore, Article 5 of the e-commerce law recognizes that the electronic communications could be recognized and it would not be considered invalid for the facts that it's made in electronic form or electronic communications. So therefore, we could just simply say that as long as the contract is made in electronic form, there's no refusal, there's no question as to the validity, assertability, enforceability of the contract for the fact that it was made in electronic form, as long as the offer and acceptance is consistent. And then the e-commerce law also have a provision for electronic signature. It's provided that any provisions that require a signature could be fulfilled when there is an electronic signature, and electronic signature could happen when it's like when the person sign it in electronic form, and then it could identify the signatory and be reliable under Clause 7 of the e-commerce law. And if we look into the definition of what could be electronic signature, the annex of the e-commerce law provided that electronic signature are a signature that are made in electronic form, and it could be that could be digital signature, biometric. Okay, so here it should be biometric signature and as well as other signature. So what is digital signature? So digital signature are the signature that could certify the identity of the signatory, certify the time and date of the signature, as well as certify the origin of the communication or transactions. And digital signature is of course regulated under subdegree 246 that talk about the requirement in order to be a legitimate digital signature. And those the subdegree require that the digital signature could be enforceable if it have a digital signature certificate issued by a licensed digital signature certificate authority. However, as of today, we are not aware of any license that have been issued to digital signature certification authority yet. So we think that digital signature is not really implemented in Cambodia. Next is the biometric signature. So biometric signature are the signature that is signed. It's the solution that you sign your handwritten signature on a hardware or device, such as a signatory pad or sign pad. So for this biometric signature, we usually see in during the bank transactions, such as like approving your credit card or debit card transactions, as well as by the government authority, like when you apply for citizenship or when the authority have to ask for your signature on your ID card. So this is also recognized under the e-commerce law as one type of electronic signature. And there are also other signature as well that is not clearly identified. So other signature, of course, could be any, as long as it is created by electronic means to identify signatory. And this, of course, could be the signature that you scan and then you upload it to the documents through the Adobe Acrobat readers, etc. So these are all considered as electronic signature as well. And there might be questions like, can I use electronic signature now? So if we look into the law, of course you can. You can just use it because the law recognizes that electronic signature could be used. But there is a tense requirement that if the contract, if you use the electronic signature for contract, you have to be aware that if your contract is valuable, we do not recommend to use electronic signature because you would not want to prove the authentication of your signature when facing with the court, because they would have to ask for whether this signature is clearly signed by the authorized signatory, so on and so forth. So yes, if you don't want to face those problems, maybe wet ink signature is more recommended for those valuable contracts or transactions. Lastly is the part that talk about sanctions. So under e-commerce law, there are several punishment types of sanctions. It could be like written warning, suspension of business operations, revocation or cancellation of license, as well as fine and imprisonments. For unauthorized operation, which is of course the operation without proper license or authorization that have been discussed by my colleague Jay. So those operations would face a penalty like 10 million real, and if repeated, it would have a double, would have imprisonment as well. And next is the failure to provide minimum information. This is quite lower, I mean, not severe punishment. So it's only face a warning, written warning. And if repeated, it would lead to a revocation of license. As for sending unrequested business communication without opt-out options, so for this, the same as the second one, which is of course the one that did it would face a written warning from the authority. And it's repeated, the license would be revocated, or the means of sending the information would be shut down, like the media that they send it would be shut down. Lastly, about the compliance with data protection obligations, they would face a fine as well as imprisonment. And there are other penalty as well. And one key point to note for offshore non-resident taxpayer that have been discussed under part 3 of this webinar, for this, they would face a penalty based on the law on taxation. And if we look on the law of taxations, of course, the penalty will be those that relating to the obstruction to the implementations of tax law by failing by failing to apply for the VAT registrations, or it could be negligent if they fail to declare tax on time. This is the end of the presentation for Cambodia. So if you have questions, please post to the chat box and then we'll answer during the Q&A times. Thank you.
Thank you, Jay and Jandavier, for a very useful insight from Cambodia side. I mean, we see that the online shopping has become very popular, particularly after COVID-19, you know, things become more easier. But I think it's also good to understand, you know, what's the actual requirement in terms of regulations and laws as well. So thank you very much. So now let's move to Laos. Let me hand over to Dino, who would take us through from the Laos aspect. Dino, over to you.
Okay, great. So I am Dino. I am the head of Tilleke Gibbins office in Laos for now more than 4 years or so. And I will today introduce you to e-commerce law in Laos indeed. So let's get started with the agenda right away. So the agenda would be more or less similar to what Cambodia introduced you all about e-commerce in Cambodia. So first part will be talking about the regulatory framework in Laos indeed. Part 2, e-commerce licensing requirements, which is actually something very new in Laos, and it's luckily we're having that webinar so we can actually explain to you what are the new things according to the new e-decree commerce that was actually published in May 2021. Part 3, disclosure information, which is about transparency, consumer protection. Part 4, online contracts called e-commerce contract according to the decree on e-commerce. And part 5, sanctions for those who do not abide by the rules of the new decree on e-commerce. So we'll start with part 1 and the regulatory framework. So here there's a lot of things to say, just because actually since until May 2021, it was pretty difficult as a legal advisor to provide a clear advice on the requirements regarding e-commerce and trading online in Laos. This is because there was not much regulation speaking about online business, none actually. And so most of the time we will rely on some regulation that would actually address typically traditional offline businesses. So here we used to rely a lot on the decision on wholesale and retail businesses, but two setback for that decision is that first of all, it talks only about goods and not services at all. And secondly, importantly, it doesn't address e-commerce or online trading at all also as well. The second regulation that we used to rely on was the decision on industrial and commercial activities requiring a business operating license, which was issued by the Ministry of Industry and Commerce in 2019. But again, same comment, the regulation didn't really address services. and just typically addressed the online activity of trading. So according to that decision, there was indeed the necessity to have a business operating license in order to operate e-commerce trading in Laos. However, that decision did not provide any information about the requirements or the condition. And as far as we know, there have been very few, or maybe not at all, very few licenses ever issued under that decision. So this is why in May 2021, the decree on e-commerce was actually published on the Lao Official Gazette. And that decree actually clarified a lot of things. First of all, that decree clarified, I would say, 3-4 different things. First of all, that decree clarified providing clear requirements regarding to licensing. So here we are talking about those digital platforms selling their own goods or services online, but also that decree specifically mentions about online marketplace services. Secondly, there was there is now a lot of information provisions regarding to consumer information on an online platform. And here we're talking about transparency, consumer protection, online contracts, about e-contracts, how the contract is formed on a digital platform doing e-commerce or online market services. And one important thing also as well is about clarification on the supervising authorities actually handling e-commerce issues in Laos. So here, actually, this is very interesting to note that in Laos, according to the decree on e-commerce, there is some kind of e-commerce authority, which is composed by 4 different ministries. And the main one will be the Ministry of Industry and Commerce here. So this is the main ministry, the main authority, the main administration, and the 2 perspectives. First, for the operators, because this is where actually the operators must go to obtain either a business operating license or a certificate. We'll see later why there is that that distinction, sorry. And second perspective is actually under consumer perspective. Whenever a consumer is having an issue about e-commerce, online trading, they can actually file a complaint with the Ministry of Industry and Commerce, which is pretty regular, I would say, pretty common in Laos, to go directly to the administration in charge to see if they can help through mediation or even fine or whatsoever that is necessary to actually solve a dispute between the professional and the consumer. Then there are 3 different other ministries: Ministry of Technology and Communication, which will actually be the one to issue, and we'll see that later also as well, a technical conformity certificate for online marketplace specifically. The Bank of Laos, which is the one to actually authorize those payment service provider to provide that possibility for digital platform to enable the user to pay online the purchase of goods or services. And finally, the Ministry of Finance. So those 4 ministries will be the main supervising authorities, but please bear in mind that most likely, even if you are a consumer or an operator, you will have to deal with the Ministry of Industry and Commerce. So briefly, very briefly, key definitions according to the new decree on e-commerce. So first of all, e-commerce. So basically it includes any type of online trading, even the exchange of goods or services that may happen on the internet or online. And here we'll be focusing actually on 2 definitions specifically, which is a owner of digital platform and online marketplace. So why do we need to make that, to focus on those actually definition? This is because those 2 types of activities are really different, and the licensing requirements will also be different. So what is an owner of digital platform? So basically that will be a operator selling its own goods or services through its own platform, or the platform that is managed on its behalf. While online marketplace is a service created by an operator where there is that kind of virtual market reuniting, gathering together seller and buyer, and where buyer would be able to actually pick up the shop that they want to buy the goods or the service from. And we will see that the licensing requirements according to those two different aspect of the e-commerce are pretty different. So the good transition now, because we're about to talk about e-commerce licensing requirements. So first of all, let's focus on online marketplace. So what do you need to actually operate an online marketplace in Laos? So one of the main documents will be the business operating license, which is actually the license issued by the Ministry of Industry and Commerce to enable operators to carry out that type of activities. One thing I would like to clarify, the decree on e-commerce speaks only about those operators operating onshore, meaning in Laos. Do not at all apply to those operating offshore. So what do we need to actually obtain the business operating license? So here we have highlighted some of the main requirements. First of all, in terms of documentation and certificate, what is required? You need to have enterprise registration certificate, meaning that this is the ID card of the legal entity in Laos, just proving that the legal entity has been duly registered with the Ministry of Industry and Commerce in Laos. Second, you need to have that technical conformity certificate I mentioned about just before, but the problem is that to date, we do not know exactly what are the requirements to obtain that technical conformity certificate issued by the Ministry of Technology and Communication. So as far as we understand, this certificate is not to be issued anytime soon, and we have like a quick talk with the Ministry of Technology and Communication, and we understand that there is a regulation underway, but to date it's just impossible to exactly let you know what are the technical requirements to obtain that certificate. Third, this is the authorization to use an online payment service. So actually, just basically, this is only a service agreement between the online marketplace and the payment service provider, whereby the two parties agree that the payment service provider will enable the online marketplace to provide payment facility to actually proceed with purchase online. One of the main requirements also as well is, as you can see, the registered capital, which actually applies only to foreign investors, meaning that there is no minimum registered capital for Lao national or Lao companies. So as you can see here, the minimum registered capital for carrying out such an activity in Laos for foreign investors is $1.05 million. And in addition to that, it's very important to note also as well that there is a restriction in terms of share ratio. So a foreign shareholder may not be able to actually hold more than 90% of the share equity of the company. 10% will have to be reserved for Lao national or Lao legal entity. What about the time frame to actually obtain the business operating license? It's 5 working days, but bear in mind that it's assuming that you already have fulfilled the requirements just above, and the duration of that license is 3 years, which can be renewable. So now, what about those digital platforms selling goods or services? How is it different? Are there any different requirements? Yes. So there is no business operating license that must be actually granted from the Ministry of Industry and Commerce, but here there will be a certificate which will be granted after a notification have been made by the digital platform selling goods or services to the MOIC. That notification, importantly, it's important to note that must be made via a application form that is to be collected at the Ministry of Industry and Commerce, but today it's not yet available. So even though the decree on e-commerce is actually in force, it's pretty difficult or impossible to actually proceed with the notification, but we understand that the authorities are working very hard on that, and it may happen anytime soon. So we do not really know exactly what type of information must be provided in those notifications. But what we know though is that there will be also a necessity to communicate some documents to the authorities at the time of the notification. And here we're talking again about the enterprise registration certificate, unless we are talking about very small businesses in Laos, like family business and so on, which may not have to actually comply with that requirement. But usually companies, legal entities will have to substantiate evidence that enterprise registration certificate proving that the legal entity is duly registered with the Ministry of Industry and Commerce. Secondly, the business operating license, if applicable. What does it mean? This is because the notification will not subtract actually the operators from applying to the relevant license in order to sell the good they're actually selling. Taking an example, if you're in the insurance sector, you need to have the business operating license to operate a insurance activity in order to be able to actually sell online those type of services. The same applies for retail activities. Whenever you're selling general goods online, but still, even though the notification is required, in order to perform the notification, you will need to evidence that you have the relevant business operating license to sell general goods offline, but also online then. And again, here we have that certificate to use online payment service. So we do not know really why the term used between online marketplace and digital platforms selling goods or services are different, because as far as we understand, according to our discussion with the authorities, here we are talking exactly about the same document, meaning that it's a service agreement between the payment service provider and the digital platform, whereby the two parties agree that they want to provide to the user, the consumer, a facility payment in order to actually proceed with purchase online, and that's it. Registered capital, so there is no, so to speak, registered capital linked to the notification, but again, it depends on the activity, and I will raise an example very soon about a very typical activity that may be carried out online, to see that there may be some restriction regarding registered capital that may apply depending on the type of good that are actually sold on the internet. Consideration, time frame to obtain that certificate after the notification is done. It's supposed to be 3 working days, so it could be more or less, I guess, in practice. Again, assuming that you have all the relevant documentation, and that certificate will be actually valid for a period of 2 years, which can be renewed anytime. So I wanted to raise a little bit of example on restriction regarding registered capital, depending on the type of activities that you're carrying out. So here, I just raising one very typical fact example. So someone who is actually selling goods offline and wants to sell also goods online must actually abide by the decision I mentioned before, the decision on wholesale and retail businesses from 2015. And again, while for Lao people, there is not much of Lao national, Lao company, there's not much of restriction in terms of registered capital. Here there is a consequent one for investors from offshore, foreign investors. So depending on the registered capital that you can see here on your screen, the foreign investor may hold more or less share equity in the company. Eventually, in order to fully own the company, the legal entity, it will be necessary to inject $2.1 million or more to fully own the company in its entirety. So this is an example actually. So notification, again, it's something that you need to do, obviously, but in addition to the notification, there will be some licensing requirements that needs to be fulfilled also as well. And here on the right side, I just note the fact that if you want to sell, so here we're talking about general goods, which will require a business operating license from the Ministry of Industry and Commerce. But if you want to sell medicine, drugs, things about like healthcare, then you may need to have an additional approval from the Ministry of Health also as well. So the next slides will be about the online payment. So is it actually necessary to seek a license or to make a notification in order to provide an online payment system to the consumer in Laos? So the response is very easy. It's no. There is no licenses or notification required from the online marketplace or the digital platform selling goods or services, by the way. Only, just as I mentioned before, that service agreement between the digital platform or the online marketplace, whereby the two parties agree to provide that type of service. One thing, though, is that there is a notification that is required, but the duty of notification does not rely on the online marketplace or the digital platform. It actually relies on the payment service provider. So basically, and this is in accordance with the regulation from the Bank of Laos, so the central bank in Laos. Basically, a payment service provider must notify to the BOL, the Bank of Laos, that they are providing a payment system on an online marketplace, name the online marketplace, name the digital platform. And here again, we are talking about a notification. So we do not foresee any obstacle made by the Bank of Laos to actually say yes or no. It's just a notification that is required, and the Bank of Laos will also indeed check whether or not that payment service provider is duly authorized by the Bank of Laos to carry out that type of businesses in Laos. So now next step, next part, part 3, information disclosure requirements. So briefly, actually the decree on e-commerce try to replicate more or less all those requirements that may apply to offline markets also as well. So there will be actually a couple of information that will be required from the operator. So for online marketplaces, or actually the digital platform selling goods and services, there is a requirement to actually indicate the name, contract details, enterprise registration certificate, but also the relevant operating license. As I said, if you are authorized by the Ministry of Health to sell medicines, then you may need to actually prove that you are duly authorized. The next thing also as well is that the decree on e-commerce mentioned specifically is information on the product or services whenever it's applicable. Here, the decree on e-commerce will require that usually all the information that may be found on labeling whenever you go in shops may also appear on the digital platform or the online marketplace. So all the information that would usually appear on the labeling should be also indicated on the digital platform and the online marketplace, as well as the characteristics and the prices and the related expenses due to the purchase of the product. Similarly, transport, method of transport, time frame to actually deliver the goods must be indicated clearly. And the payment, the method of payment and time frame about that payment will also be required. One thing that is specific to online marketplace is that there must be a consumer opinion area section where all the users of the online marketplace must be able to provide their opinion, and also we may need to see the content of this opinion and the number of the opinion provided. So here it's pretty unclear what the opinion should be specifically. For instance, we do not know if it could be just stars or should it be also text, something very precise. Lastly, the decree on e-commerce also emphasize on terms and conditions that should be also displayed on the website, and specifically on the reimbursement policy and product warranty. So now, briefly, before I pass the floor on to my colleagues in Myanmar, I will just talk about e-commerce contract. So that's an interesting part also as well of the decree on e-commerce. They do talk about online contract, or accurately, according to the decree on e-commerce, it's e-commerce contract. So here, what the decree provides is that there is a necessity to have mandatory content in those e-commerce contracts. So here, in the contract should be appearing service, product, method of payment, transport also as well, but also information such as possible amendment, what happened in terms if there is any breach of the contract or termination. So it may be pretty difficult actually to see how this may be included in the usual online marketplace also as well. And in addition to that, indeed, name, address, telephone, and email of the customer must be also indicated. One thing also to note is that that e-commerce contract should be made available through either a system on the website that may enable the user to actually go and check their e-commerce contract at any time, or to make it printable at any time also as well. Effectiveness, so the contract on digital platform and online marketplace will be formed when the seller will actually agree on the request made by the buyer. One thing which is very important also to note is that there should be some kind of mechanism for the user to be able to review before actually ordering the goods or the services online. So here there should be a mechanism in order to edit, amend the order that is to be made, to confirm finally, or indeed to cancel the proposal before proceeding further to the order of the good or the service. And again, there should be also a requirement, a mechanism, sorry, regarding to the canceling of the purchase. So here is, as we mentioned before, the purchase is made, the contract is formed as soon as both parties agreed, and specifically here, when the seller agreed on the request made by the buyer. So during that time, there should be a mechanism, a function that allows the buyer to actually cancel the purchase at any time before the acceptance from the seller. So finally, the sanctions actually that may be imposed on the operators operating e-commerce in Laos. So I have to say the decree on e-commerce is not very exhaustive, and we believe that it will be subject to maybe additional guidance from the authorities in this regard. So the decree on e-commerce just provides very broadly that depending on the type of infringement, depending on the type of the offense, then the infringer may be warned, educated, face disciplinary measure, fine, or be subject to civil or criminal charges. So it's very broad, and we believe that it doesn't help to the implementation or application of those sanctions. It will be for sure subject to more details later on by the authorities, and it poses also some question to the current implementation of the decree on e-commerce. This is because, as you have seen, some let's say the technical conformity certificate is not yet even available. Notification cannot be done as yet. And here again, we see something that is pretty very broad and doesn't help the officer actually to take any action in order to sanction. So we believe that the Ministry of Industry and Commerce has broad power to impose a sanction that they deem fit, but unless this is something very serious, it may be very difficult to date for the officer to impose any sanction on those infringing the decree on e-commerce. But the decree on e-commerce will be soon fully enforceable. And also, this is a very clear guideline for all those people involved in online activities, online trading, on what to do to actually comply as soon as possible with that regulation. So this is it for me, actually, for Laos. Thank you very much for your attention. Again, we'll take some questions later, so please do feel free to share any question you may have in mind for the Laos jurisdiction also as well. Thank you.
Thank you very much, Dino. And there's some questions for you, and we leave towards the end of the sessions. So with conscious of time, let's move to Myanmar. I will hand over to I and Yuvadi to take us through Myanmar from Myanmar aspect, please.
Hi, good morning, everyone. Welcome to Myanmar sessions. For us, and as you may know, Myanmar have some law regulation, and in 2018, they also have the regulations for allowing for wholesale and retail in Myanmar, for allowing for the foreigners to conduct the trading business in Myanmar. However, about the e-commerce business in Myanmar is very interesting because it's some new challenge and new regulations that this part A to slide will be present for you about the term and regulations. For this today presentation, we will present about the introductions of the general legal frameworks that related about the e-commerce in Myanmar, and also explain about the related provision and law and authority that handling about the e-commerce business in Myanmar. Actually, we can mention about the online platform at the existing platform in Myanmar, because the e-commerce law did not implement yet in Myanmar. That's why we need to be rely on the existing law and regulations to comply with about the online platform in Myanmar that A to Salai will be present to you all. Another one is about introduce about the draft law for e-commerce in Myanmar. We already received the draft of the law. That is interesting. This is for your guideline for the futures or the operator who already run and operate for the online platform in Myanmar to be guided But as this is a draft law, maybe is subject to be changed in the futures. And the last presentation for us, it will be about wholesale retail regulations and the existing required practice and requirement for you to be guided if anyone would like to establish the trading in Myanmar. Okay, it's time. Etu Salai, please start your presentation, please.
Yes, Kongai. Hello, I am A from Tilleke Gibbins Myanmar office. Today I will share our research about the existing laws and regulations that can be considered related to the e-commerce in Myanmar. Here, firstly, we would like to share the general legal framework and scopes of law that are relating to the e-commerce activities currently in Myanmar. Here are the 8 laws that is mainly related to the e-commerce activities, depends on the types of goods and services. I simply listed the laws completely here, but I will not read and explain everything in each slide. For next slide, I will explain a very detail of this law. So I will move to another slide. Here, for this existing legal framework, here is the supervising authorities for this law. Firstly, Ministry of Transport and Communication. It is related to the electronic transaction law and telecommunications law. And another one is Ministry of Commerce of Myanmar. This ministry governs the competition law, the consumer protection law, and export-import law, and the 4 Myanmar's enacted IP intellectual property laws. And lastly, the Central Bank of Myanmar for the mobile payments and cash payments, which e-commerce business deal with the existing banks of Myanmar. The rule of Central Bank of Myanmar is required. In this slide, we would like to also share about the draft e-commerce guideline of Myanmar. It was drafted since 2020, but according to the current situation, it has not to be enacted yet. And another one is for your knowledge, we would like to share about the multi-level marketing activities. These are prohibited by Notification 46/2018 of Ministry of Commerce Myanmar. And just for your knowledge, we would like to also share about the gambling law and the draft direct selling law in Myanmar. So let's start with electronic transaction laws. The Myanmar has not yet any e-commerce law. Every electronic transaction, electronic data message, and which are for commercial or non-commercial purpose. These transitions can be defined under this electronic transitions law. I added the relevant sections here for your information. In this slide, I will talk about telecommunications law. It is concerned with the data privacy of the consumers. For e-commerce business, they need to run through an online platform. That online platform and mobile operators are licensed under the telecommunications law, network license. But for any breach of data or leak of data breach arise, the liability will be up to the network license holders and not directly to the e-commerce business owner. Here, I would like to explain about the existing competition law of Myanmar. In this competition law, the purpose of law is for all the business to prevent from monopolization in the market and to follow the business ethics and to follow not to misleading the customers, consumers, whether in the e-commerce or non-e-commerce business. Here, we will continue about the provisions from competition law. The law prohibited for selling the goods at a lower price than the actual production cost in order to avoid unfair competition in the market, whether it is e-commerce or non-e-commerce. So another one relating to the e-commerce in Myanmar is consumer protection law. Every product and service selling in the Myanmar has to comply with consumer protection law. The law has completely two parts. One is the obligations of the business owner, and another one is to comply for the product labeling of the products. Here I put the definition, a detailed definition of the law for your information. You can receive the presentation slide after we have finished the webinar, and you can request also. So here I put details of the obligations of business owner, whether e-commerce or non-e-commerce. The business owner must comply with this provision from consumer protection law. Okay, here is the labeling patch of the consumer protection law. The products must mention the criteria for labeling, including name, size, net, weight, manufacturer date, and so on. Here you can check the details of the labeling requirements under the consumer protection law. Here, financial institution law and cap payment instructions are governed by the Central Bank of Myanmar. According to the nature of e-commerce business, it is required to comply with to receive online payments, mobile financial service payments. So if there is any special condition, for example, selling of the gift voucher, lucky draw tickets for their products and service, the e-commerce business may require to deal with local authorized banks, and both these banks and e-commerce business owners are required to acknowledge to Central Bank of Myanmar for under the compliance of financial institution law and cap payment instructions. Here, for more details, you can check here when local authorized banks and e-commerce business owner acknowledged to Central Bank of Myanmar, the Central Bank of Myanmar Deputy Governor's Office will review the acknowledgement and application for their further approval or permission by case basis. But for your notes, here for the e-commerce business that requires special accounts and conditions to be reviewed by Central Bank of Myanmar. It has to be a foreign entity, maybe hold up to 35% of the company shares, or a local entity that hold at least 65% of the company share. It means that the applicant company must be a local company according to the Myanmar Companies Law. I will move to the next slide. We would like to explain about the export and import regulations by the Ministry of Commerce. As Myanmar is a developing country, most of the products selling in the market, whether e-commerce or non-e-commerce, are mostly imported products. So these imported products must comply with the export and import laws and regulations of Myanmar. Some of the products are restricted for trading by foreign companies in Myanmar. So for this solution, Ministry of Commerce regulates for the wholesale and retail notification, and the foreign companies are to comply with this wholesale and retail requirements. Khun Yuri will explain in the next slide. Here I will continue for the another draft e-commerce laws of Myanmar. Before talking about the draft e-commerce law, the four intellectual properties law, including trademark law, patent law, and copyright law, must be considered for the e-commerce practice in Myanmar, because if selling the counterfeit goods buying online, buying e-commerce, it may be illegal according to the full intellectual properties law that's already enacted in Myanmar. In this slide, I would like to share Myanmar Ministry of Commerce drafted an e-commerce official guideline, we can call short in MEOG, that was adopted in 2020, but according to the current situation, it cannot be enacted at all. In the draft law, according to our research, the Ministry of Commerce draft for the issuance of certificate for the e-commerce business if the MEOG has adopted. In this draft, the MOC also include for the intellectual property and its infringement to cover for the e-commerce business. Okay, here is gambling. You may consider why gambling is related to the e-commerce business, but for the business entrepreneurs' knowledge, we would like to share to avoid the gambling activities by e-commerce means because there is a gambling law exists in Myanmar, and it may be illegal if you are betting money and accepting money for some kind of skillful gaming by e-commerce. For example, you prepare a lucky draw program for your customers buying online, and you receive money from them, and you will give back very valuable things by passing a skillful gaming procedure, something like this. So another one is direct selling. As I discussed in earlier slides, multi-level marketing activities are currently prohibited in Myanmar. But if direct selling laws it will be enacted in the future of Myanmar, it may have to allow for multi-level marketing activities, but currently it is not available for MLM activities. Here is the detail of prohibition of multi-level marketing activities by notification 46/2018 by Ministry of Commerce. Okay, this slide, it is about the requirements for wholesale and retail notification. I would like to invite our director, Kunyuwadi, to present this slide. Thank you for your kind attention.
Thank you, Etusa. Thank you for the guideline and existing law and regulation about the e-commerce in Myanmar. As you may see from the presentation of my colleagues, Ms. Etusa, you can see that in actually the related law, for example, consumer protections, competition laws, IP laws, and also about import and export law, it's already mentioned about for non-e-commerce and e-commerce or non-commercial and commercial matters. It means that if the relevant authority would like to take action about any online platform, actually they can do based on the existing law and regulation if they found any breach of any law that concern. Even they don't have direct e-commerce law to be enforced at this present. And also, if you can consider about the draft of the e-commerce, can see that mostly mentioned about is will relate about the law and regulation that direct depend on the good and service that you sell via e-commerce platform as well. It means that we assume that the e-commerce platform or e-commerce law that will plan to be issued is will about the guideline and considers and definition about the e-commerce business. And for the law and regulation for the sanctions of the person who breach with the e-commerce will be under the law and regulation that already established or exist in Myanmar. This is the one that we would like to aware, or any online platform that already launched and established in Myanmar to be concerned about the existing law that already implemented and enforced in Myanmar, for you consider as a part of the when you operate for the e-commerce platform in Myanmar. Okay, for my side, I will start about the wholesale and retail. Wholesale and retail business, why is related to the e-commerce platform? This is because this rule or notification is direct about the tradings that allow for the foreign entity or foreign joint venture to trade in Myanmar, because previously there have many restrictions for the company or even individual to do the trading business in Myanmar. This notification is issued to support for considering who can operate the trading business in Myanmar, that they're separate for two types about retail business and wholesale business. Retail, what does this mean? Retail is mean to sell to the direct to customer by the individually or piecely, or by piece, or you need to have the shop establishment and have the shop to be sold direct to your customer. However, for the wholesale, it depends on the big volume. You need to sell to the manufacturer or retailer or dealer. This is the summary of the definition of the wholesale and retails. What is the required documents or the initial capitals? For the foreign owned 100% can establish and set up the company under retail or wholesale by maximum with USD 3 million US dollar for retail and 5 million US dollar for the wholesale. Even you have the my foreigners is have my if the majority share, so at least 80% of the share, you will consider the percentage and the initial capital the same as the 100% owned by the foreigners. However, if that company established by having the local citizen or local entity or local company and have the share more than 20% or at least 20%, the initial capital of this company for the retail will be 7,000 US dollar, and also for wholesale will be 2 million US dollar. This is can see the difference about the amount of initials. However, it seems like they will try to have some more encourage for the joint venture size. However, if your business is big enough, you can have the investment. However, for the investment, they also have the condition for the investment. For example, for the first year, you need to pay at least 50% of the total amount of the initial capitals. And then the second year, you can pay 30%. And the third year, you can pay 20% of the remaining amount. Which one that you would like to establish by the option in the tables. Okay, if, for example, I want to establish for the both wholesale and retail with 100% owned by the foreign shares, it means that I need to have the initial capital for 5 million and also plus with the retail 3 million for establish the retail. It means I need to have the first initials for my business for both wholesale and retail is 8 million US dollar. Next slide, please. Okay, this is a requirement of the company who would like to extend your business or establish for the wholesale retail in Myanmar, the retail business, they have some minimum requirements that quite important to consider for the retail business. Is this they require at least 929 square meters at one roof. It means you need to have the shop that opens some kind like the one standalone for the people to come and buy directly. Mostly it's some kind like some shop and supermarket do it this with independent by themselves. And also wholesale business that require they don't have the minimum requirement of the size of the business or location, but they need some warehouse, have the sufficient space to operate for the appropriate locations. This one also, the both wholesale and retail for their location need to get approval by the local authorities. If your location is in Yangon, it means Yangon committee will be considered and approved for your business license to establish retail and wholesale. For the MIC permit or endorsement, it may require if you would like to have the long-term list. As you may note about for Myanmar, for the foreigner, you can at least rent or lease the agreement only 1 year. But if you need to have the long-term, you need to be registered. But if you get the permit for MIC or MIC endorsement, you can get long-term, for example, 50 years plus 10 years 2 times. It means totally 70 years. The important requirement about for wholesale and retail is about you need to have the business plan for 5 years to plan about your business, even retail or wholesale, for the MOC to consider and approve for your business structures and business operations. Okay, for that amount in previous slide about the table, you can see that it is a huge number of the investment. However, the MOC also allow you to have the offshore loan. It means loan from other country for the investment in Myanmar because they need the outside investment for this type of business in Myanmar. Okay, next slide. Okay, about for the sanctions for the non-compliance for wholesale and retail, based on standard procedures that issued by the Ministry of Commerce, that's just the first thing for the business that run as wholesale and retail but not obtain the wholesale retail license. The first one, you will get the warning letters from the Ministry of Commerce to comply with the wholesale and retail applications. If not, the Ministry of Commerce will take the action for you based on the import and export and import law in Myanmar by the illegal importation with an authorization or without the required license and certificate. This one, and also will take action based on the law that mention about the goods that you import. For example, some illegal product for wildlife. This one, they will have another law for the wildlife against you as well. Further for the export and import law. Okay, the next slide. Okay, for Myanmar, this is I can conclude about they have the regulation for the wholesale and retail to be operate for tradings and also for do the commercial operations, and them they don't have any restriction if they want to run by online, but they need to have the existing business operation and location under the existing regulation of the Ministry of Commerce. This is for Myanmar. Thank you very much.
Thank you very much. That was very useful information. So now let's move to Q&A. We received quite a lot of questions, so we try to answer as much as possible. So let's go to the first one. And thank you, Jay, for answering most questions from for Cambodia. So let's move to the question for Laos. Yep. So this is a question for Laos. It will be for you, Dano. So the question was, we understood previously that the e-commerce decree does not address sanctions for non-compliance. However, your slide earlier suggests that decree does provide broad sanctions for infringement. Could we clarify if decree does provide for sanctions, or if the ministry powers to issue warning, education, discipline measures, fines, and from other laws in Laos?
Yeah, thank you for the question. So I think this is the provision that is actually included in the decree on e-commerce is a typical clause provided by the government authorities in any type of regulation or laws. But from our experience, actually, it shows that whenever there is such a broad clause, broad provision, talking about sanctions which are not quite clear, it's very, very difficult to actually be implemented in practice. This is because the decree on e-commerce does not say any specific infringement. They say just broadly any type of infringement may be subject to sanction and so on. The same goes for the fine. If there is no sliding scale relating to fine, that will be most likely very, very, very difficult to actually implement. So that's why in the presentation we said that indeed there is that broad provision that provides the Ministry of Industry and Commerce mainly the ability to issue a sanction, but in practice it will be very difficult. And in any case, we understand that according to our practice regarding to previous regulation that were actually issued, and the same happened, for instance, on the decision on 2015 relating to wholesale and retail businesses, there was some kind of grace period where the businesses had to adjust to the new regulation. And even after that, the sanctions that were actually issued by the local authorities were warning. Just we give you 3 months, 6 months, I don't know how long, it depends, I guess, on a case-by-case basis, in order for your company to actually comply with the law. But according to the current state of the decree on e-commerce, by law, yeah, I mean, there is a possibility that sanction may be actually applied, but in practice, we believe that it is unlikely unless there is something very serious happening. For your information, generally, I would say the Ministry of Industry and Commerce has a very broad power in any case to do whatever they want to do to withdraw licenses. But without clear indication in the decree on e-commerce, I believe that to date it's very unlikely that any sanction may be applied precisely. And we know for a fact that the Ministry of Industry and Commerce is also working on the clear guidelines to implement specifically sanctions also as well.
Thank you. Just another short question as well from one of the audience. The cooling off period is legally applicable for e-commerce trading in Laos?
So the decree is actually in force since June 4, and businesses have 90 days to actually implement the provisions of the decree on e-commerce. But it's good also to still bear in mind, as we noticed during the presentation, and it's like a little bit like what happened in Cambodia when I heard my colleagues saying that there is some notification requirements, there are some requirements also to obtain a business operating license, but where can you get the form to actually make the request to the authorities? There is no form to date. So basically, yes, there is a regulation, there is things that you need to comply with, but in practice, it's very difficult. So let's say you have 90 days for 3 months as for June 4th to actually comply with the law. But for most of the provision, you will not be able to do so, even if you really try very hard, because you don't have the application form to do so. So it's like in kind of actually transition period for now, and the authorities are trying to catch up with developing further guidelines for implementing correctly the decree on e-commerce.
Thank you, Dino. With conscious of time, let's move to some questions from Myanmar. Earlier this year, the MOC chaired private sector the draft e-commerce guideline for operations in Myanmar. Has there been any progress on this?
Yes, I will answer for this question. As we refer in our presentation, it is the draft guideline for Myanmar e-commerce. According to our follow-up and discussion with Ministry of Commerce within this month, there is no further progress for any improvement due to the current situation of Myanmar. But we will keep follow-up and posted, and if any further updates, our fund used to issue a newsletter in our website. You can check.
Thank you.
Thank you.
And another question from Myanmar, please. Whether the wholesale retail regulations applies to e-commerce, and otherwise, what are the restrictions on operating an e-commerce business which involve retail in Myanmar?
Okay, I will answer for this question. Initially, they have, if you already obtain the license for the wholesale and retails, they don't have any restriction for you to sell your product by online platform of your website, your own websites, because you already get an approval for trading your products in Myanmar. However, as you know, the e-commerce regulation is not implemented yet. That's why you can do buy online based on the existing law that allow you to sell and trade things. But it doesn't mean you can sell your products by others who not obtain the license wholesale and retail in other platform. But in your platform, it don't have any restriction on these matters based on the license that you already get an approval by the MOC, and you already have the business location in Myanmar. Okay.
Thank you. And now with question for Cambodia, please. Is there a mechanism yet for offshore company to register VAT in place for them to pay that to the Cambodian tax department?
That's a really good question. So thank you. So currently, no, there isn't. So you have the regulation, the sub-decree number 65. So it sets out the framework. So it's clear that there will be an obligation for offshore companies with certain levels of business to register for the purpose of collecting and paying VAT. But currently, as we understand, there's no application yet available. So I think what we'll need to see is some more implementing regulations that make it clear exactly what sort of documents need to be provided to register as an offshore company. So I think the advice for offshore companies is, be aware of this obligation. I think you'll have to start to get ready to implement it at some point, but I think right now you can just watch and wait for more implementing regulations.
Thank you. So another question is sort of related to the previous question as well. So is there any inspection or body authority in Cambodia who will look over the online business, or who should apply for the license or authorization?
That's also a very good question. So currently, the Ministry of Commerce and the Ministry of Post and Telecommunication, they have broad oversight powers under the e-commerce law. And as we mentioned, both the Ministry of Commerce and the MPTC have licenses that are relevant for online businesses. However, we're not aware that there's necessarily a task force or that anybody within those ministries has been specifically empowered to go around and start looking to see if you have these licenses or not. That said, I think if you are a domestic company here in Cambodia and you are doing e-commerce and you haven't registered, then you'll be sort of an easy target. So it's certainly possible that they might find you, and then there would be penalties if you don't comply with the law. If you're an offshore company, I think you can really wait and see, because one, for offshore companies, it's not really clear that you could actually meet the documentary requirements to apply for an e-commerce license. So in that sense, I think for offshore companies, you can wait to see if the Ministry of Commerce and the MPTC really tries to apply to offshore companies. But if you're a domestic company, I think even though there isn't necessarily a specific committee that we're aware of, there's just a greater likelihood that there'll be enforcement actions against you because I think it'll be just easier to find.
Thank you very much, Jay. And I think there's more questions, but with conscious of time, you can email speakers all your questions and they will be answered after the sessions. And after the session, there will also be a survey. And once you complete the survey, you will also get the slide from our lovely speakers. And once again, thank you for all your participations and thank you all our speakers for the very useful information today. And here's we can end. It comes to the end of our sessions. Thank you.
Thank you very much.
Thank you so much,
everyone, for
Thank
your
you.
time.